We are pleased to have two partners from Ogletree Deacons, which is a national employment law firm, Janice Dubler and Dan O'Meara. Dan has spoken in the past with us. And we've asked them to talk about marijuana in the workplace in a general sense, not in a state-specific sense. As we know, there's a very rapidly changing landscape out there amongst the states. So we kind of want to get a sense from them about what's happening in other states where marijuana has been legalized for a while and what to expect and kind of what the trends are. And then, as always, Amy McAndrew will finish with a COVID update at the end. So Dan and Janice, let me turn it over to you.
Good morning, everybody. Hi, thank you. Medical marijuana is now legal for medical use in 36 states, plus a whole bunch of territories like DC, Guam, Puerto Rico, Virgin Islands. And some of those statutes that legalize marijuana for medical explicitly require employers to accommodate medical marijuana in the workplace, and others are silent on it. And we have seen courts interpret these medical marijuana requirements all over the board. And some courts have found, hey, medical marijuana is still marijuana. Marijuana is federally illegal, and employer, just because it's legal for somebody to use it doesn't mean an employer has to accommodate it. And they've said employers can kind of still go and do what they regularly did, while other courts are saying, hey, medical marijuana is medical. You have to treat it like any other medication. If somebody's legally using it in their state through a prescription, you have to go through the reasonable accommodation process and engage in the interactive process. Setting a landscape, 36 states have medical marijuana, and then we've got 16 states plus District of Columbia that actually permit recreational marijuana, which means that the employee doesn't have to have a prescription at all. So just with that as the landscape, I'm going to turn it over to Dan to talk about.
Sure. I'm going to talk about first the sort of history of the case law, all fairly in the last 5 years or so. On the issue of if someone has a medical marijuana prescription and uses medical marijuana, does that affect their rights in the workplace? The first answer in the first wave of cases was no, it doesn't. Employers still have the right to have a drug-free workplace, terminate employees, whether they have a prescription or not. They have a prescription, that means they can use it, doesn't mean they can hold on to that job. Lead case there was a case called Dish Networks, came out of the Colorado Supreme Court. And it dealt with a young man who had been made a quadriplegic in a car accident when he's 16 years old. He's in his late 20s. He'd been employed by Dish Networks for a number of years, had very good performance evaluations, was a valued employee, and was sent in for random drug testing one day. He tested positive. He had a prescription for marijuana, helped deal with the symptoms of his quadriplegia. Dish Networks fired him. Notwithstanding the optics, the case went up to the Colorado Supreme Court. Colorado Supreme Court said that was fine to fire him and Colorado had a statute that said employers can't discriminate because of lawful outside of work activities against any employee. They said, well, it's still a violation of federal law, the Colorado Supreme Court said, and so therefore Dish Networks could fire them and did fire them, and it stood up. That was 2015. And that was perhaps the most extreme of a series of cases that said medical marijuana laws don't really change the workplace as it existed before. Then came a Massachusetts Supreme Court, or Supreme Judicial Court, they call it, case in 2017, the Barbuto case. The Massachusetts Supreme Court said there's no basis to sue the employer under the Massachusetts Medical Marijuana Act, but there was a basis to sue under the Massachusetts Fair Employment Practices Act because the employee in that case was taking medical marijuana as a treatment for a disability. Massachusetts law, unlike federal law, has a provision prohibiting disability discrimination, requiring a reasonable accommodation of a known disability, and in addition, requiring the so-called interactive process you're probably very familiar with from the ADA, in connection with reasonable accommodation. There, the person that tested positive was a medical marijuana holder. The employer said, you tested positive, boom, you're fired, or you don't get the job. That was found to be a violation of the Massachusetts FEP law because the person had a disability. The employer had not gone through the progressions to see if the medical marijuana use was a reason, allowing it and allowing them to work there was a reasonable accommodation for the disability. So it's one of those cases where had the employer had a conversation with the person about the issues, it would have been a much better position legally. And basically, starting with that case, there have been a wave of cases around the country holding just that. Now, ironically, I'm going to turn it back to Janice to discuss New Jersey law. In Pennsylvania, things are somewhat the opposite of where they are nationally. The Pennsylvania Human Relations Act does not create an obligation to reasonably accommodate medical marijuana use, because the way it's written, you don't have to accommodate illegal drug use as defined by federal law. The courts have said they could have incorporated state law, they didn't federal law. So there's no duty to reasonably accommodate in Pennsylvania, or so says the one lead case on the topic. There is, however, a provision in Pennsylvania's Medical Marijuana Act that prevents employers from discriminating against employees solely because they have a medical marijuana license or solely because they use medical marijuana. If the employer is of a mind that medical marijuana or any marijuana will impair someone on the job, then maybe that's a different decision than solely because they have a license. But it still leads me to counsel Pennsylvania employers. Say you have an applicant who tests positive as a medical marijuana license. I still suggest they go through that interactive process as it relates to the statute here to say, what causes you to have it, more specifically, how often you take it, how does it affect you? You may want to incorporate the employee's physician or company physician, but you talk about the job to which they're hired. Frankly, if you're overhead crane operator in a production facility, the decision about whether you want to reasonably accommodate their marijuana use can be a really short decision. You can hear about it, you say, no, we know this job. We don't want anyone, even if they used the night before, be operating that job. On the other hand, if you had a phone bank of 300 customer service representatives and the person tests positive, and so maybe in that case, you would hire the person nonetheless. But again, employers in such situations are well advised to not have blanket policies saying, no marijuana use. And I'll discuss later in the presentation, federally regulated safety sensitive positions, which is a different analysis. But if the employer has discretion on what to do, it's well advised to take a situation specific view, gathering information from the employee, and to make a decision on that job and that employee and that employee's use, whether the employer wants to hire the person. Janice?
Yeah, I just super quickly, we can do a 5-hour all-day seminar on New Jersey, but just want to point out that New Jersey's legalized recreational use of marijuana by adults who are 21 and over, kind of like alcohol. And it's the only state in the United States to explicitly protect employees who engage in off-work marijuana use from adverse employment action. It specifically provides that employers can't take adverse action against an applicant or an employee because they've tested positive for marijuana. And to me, what's the most interesting, and we're going to have to see how this develops, it's just a work in progress. We're still waiting for regulations, but there are no safety sensitive exceptions to the rule. Originally, when they drafted the statute, this language ultimately didn't end up in the statute. They said an employer could take an adverse action as long as there's a rational basis for doing so, reasonably related to the employment or the employee's job responsibilities. And that did not make it to the final legislation. So right now, recreational marijuana use in New Jersey is a protected class, or it's going to be. So we're waiting for regulations. There are a few other kind of strange requirements in the legislation, including that you have a physical examination of an employee that's conducted by somebody called a workplace impairment recognition expert before when you do drug testing. So, I guess what I would say about that is Dan's principles still hold that an employer can still ban using, consuming, possession, being under the influence in the workplace during work hours, but it's really, really up in the air, which jobs and how this is all going to play out for employers who have employees who they consider to be safety sensitive, but making blanket rules. So with that, I'm going to turn it back to Dan.
Cool. And I now get to answer a question that was raised by Manny. Let's talk about different industries, different job types, et cetera. And I'm going to hazard some predictions on change in the American workplace. Let's talk about first something that I don't think is going to change, which is the regulation of employment concerning safety sensitive positions, commercial truck drivers, train engineers, commercial aircraft flight crew, and there's probably several more. All these occupations were subject, starting in about 87, 88, to very strict drug testing protocols and zero tolerance policies. I predict that first off, New Jersey law does not change that. None of these laws change that in any way. Federal preempts state if there's a conflict, and the federal laws are quite clear, and nobody's even fighting the concept, to my knowledge, of do these state laws affect on these safety sensitive positions. Will the federal government change its approach to testing and zero tolerance? I don't think so. Couple reasons. First off, at the time this testing was implemented, there were a series of studies where they would, in a truck driving simulator or flight simulator, they'd have someone in there, doing it, being tested extensively. The next day they'd use marijuana and then do the same thing. And all the operators, the truck drivers, the pilots are saying, no, it didn't affect me at all. And the people running the machines are like, yeah, glad you think so. Well, you just crashed the plane 3 times. How do you do that? Or crash the truck? So there's very extensive, seemingly scientific evidence of the effects of impairment and even the effects of impairment the next day, that it caused lack of control and other negative things. So unless there's a series of new studies contradicting those studies, I don't see any regularity going out on a branch to change this. And also, I think one of the reasons there's not much pressure to change this is the incumbents in these roles seem to have self-selected in this sense. Basically, I know people who had a love of flight and a love of marijuana. And it reminded me of that 1976 song, Torn Between Two Lovers. Well, you got to decide. Well, they did decide, and they decided if they want to be an aircraft pilot or a truck driver, they would just give up all illegal drugs and all prescription use of marijuana, et cetera. So I don't even see a lot of pushback among incumbents in these positions to change that, because they made their election. And I think they know how absurd it would sound for holder of a CDL or an aircraft pilot or a train engineer to say, no, what about my rights to use marijuana? It's enough of a non-starter. So I don't see that first off, none of these state laws change that at all. And I don't see it changing on the federal level at all. Let's talk about other areas that I don't see changing real quickly. I represent some frackers in Pennsylvania. They believe, the HR people in any event believe, as hard as it is to get people in there to do that work who test cleanly, that it is important. It's part of their relationship with their workers' comp carriers. They believe that someone under the influence or even a casual user would put themselves and their fellow employees at jeopardy. And last I talked to them, they just had no desire to change what they call their drug mitigation protocols. There might be stuff going on there, I don't know. But as of a couple of years ago, they were more ready to fly someone up from Oklahoma who would pass the test than to hire someone from Pennsylvania who didn't. And there's also a group of other employers that may not be in these safety sensitive positions, but have agreements with companies that have strict drug testing protocols. I talked to one owner of a company who does environmental remediation work, and he had told a few stories about his high school years, which made me think he had no moral opposition to marijuana use, even though he is not a user. And I said, "Are you thinking about changing that for your company?" He said, "No." Why not? He said, "First off, our biggest client group are pharmaceutical companies. They're very good clients. They all make us to agree that we will have strict drug testing protocols for any employee working on their job." He said, "I also got people driving around in cars and trucks, and even if they aren't CDLs, he just, once it's set up, once the employees in those jobs are accepting of the restrictions, he just saw no need to revisit that." But let's talk briefly about an industry I think will change a little bit and has changed. Let's talk about the pharma business. Now, people in the audience may say, "I work in pharma, it's not changing yet." And you might be right. But pharma, as of 20 years ago, had a very, to my eye, a very anti-recreational drug philosophy, including zero tolerance of its drug detailers going out there. Now, why is that? I had always thought it was because pharmacy school can be a magnet for more mentally sophisticated substance abusers, and they all get blown out after a while. But I thought that was the driving force behind the anti-drug philosophies. But it's been pointed out to me at the time that a lot of the detailers are out there operating cars all day long. In fact, they spend more time driving than they do meeting with doctors, and also the optics of prescription of a pharmaceutical company having illegal drug use among its employees, I think was just thought to seal the deal and to cause strict prohibition. I understand that this is changing. There's greater thought in the pharma community, acceptance of the medical benefits of marijuana. There's national employers in that business who know they've got to comply with state laws. Now, New Jersey, there's a ton of pharma work in New Jersey. Frankly, with the pandemic, they've found ways that there's a whole lot less driving and more Zoom calls. And as shared with me one pharma exec yesterday, they're also thinking, how do we let this pass us by? Why aren't we selling this stuff? Basically, if it's medical, and they stayed out of it for a lot of reasons, including the federal prohibition. But in general, there may be a move away from strict zero tolerance in the pharmaceutical industry, in a lot of other industries. But I gave pharma as an example because it had been so clearly anti-recreational use previously. Janice?
I mean,
I can keep talking, but
I mean, I think, Dan, you and I had a lot of conversation about kind of what is a safety sensitive job, because there's the obvious jobs that involve driving a heavy truck or that are federally regulated so that you can have the federal statutes preempting it. And then there's the obvious like retail jobs or something where maybe it's pretty obvious it's not safety sensitive, but there's a whole lot of in between. And I think that's where the litigation is going to be developing. So for the non-safety sensitive jobs, Dan, are you recommending, or do you have thoughts? I hear anecdotally that a lot of clients are going to just not test for marijuana anymore, and only if they think somebody's under the influence at work are they going to even do the test. And I'm wondering your thoughts on that.
there is a big movement to dropping marijuana from the initial testing drug screen, including in healthcare, one employer I talked to. But let's talk about if an employer is thinking of dropping that, what factors should it consider? First off, you're going to want to check with your CGL insurance, your comprehensive liability insurance, to make sure you don't have any reps or provisions in there that require you to test for marijuana. Same thing with your workers' comp policy. Same thing with any third-party contracts you have with customers, et cetera. And of course, make sure there's no regulatory obligations to test. But if that's all clear, and frankly, this is more of a poignant point before the pandemic when there's an ongoing labor shortage, but it's going to happen again. I've talked to some employers that say, we want to knock that off the panel because it's keeping us from getting otherwise good quality employees. It's requiring us to not hire, say, a nursing home. a CNA with 18 years experience who just relocated to the area, who's got great recommendations, who'd be a great CNA because they smoked marijuana 25 days ago, and instead hire someone with no experience and a terrible employment record. The people I talked to said, I'd rather have the first person in there treating patients than the second, and they think they're going to get a better quality workforce if they drop that panel. But it's a very situation specific thing. And in terms of messaging, even internal emails, I wouldn't put anything like, geez, with the small amount we're paying to employees, we really can't be that picky. That'd be the opposite of what you want to say. I think what you want to say is towards getting a better quality workforce, the workforce that we will supervise. I'd like to have us discuss dropping the marijuana off the panel. And there are a lot of employers doing just that, both for employee retention and recruitment reasons, but also adapting to these new laws that really make it fairly complicated.
You know, and I think the other things, just before we turn to the questions, Dan, that folks should consider is just, you know, everybody should be really constantly looking at their drug testing policy and making sure that it's up to date. You know, if you can't make a pretty liberal policy that satisfies all the states, consider having riders for your different states. And just make sure that you're really educating your supervisors and managers about this, because a lot of folks really have what are now considered probably dated views about this. And you just want to make sure that everybody's up to speed on what is and isn't okay in your company. I also think it's a good idea to make clear before you have an issue, which jobs are safety sensitive, which jobs aren't safety sensitive. So that way you have a good defense to be able to say that this is a safety sensitive job. Dan, anything else on kind of recommendations and suggestions?
Yeah, there's a question. What about medical office professionals like RNs? That's exactly the type of question I've been trying to avoid because I don't have a good answer for it.
You know, Dan, we've been looking at this a lot in New Jersey because, like I said, there is no safety sensitive projection, and I've got clients that employ, you know, 1,000 RNs, and they're sort of like they're involved in clinical care, and how am I going to deal with this, and what am I going to do? And I think the answer is, I mean, the answer, there is no right answer. We don't have the regulations yet, but what I would say is handle it on a case by case basis. And at the end of the day, if you're balancing a potential employment case with a potential malpractice case, I mean, to me, if you really think it's a safety sensitive issue and that the patient safety is at issue, I would err on the side. I think it's the right thing for now until we get the regulations.
Yeah, I think that's exactly right. And every healthcare professional I know says that job one is patient care. And so you might have some New Jersey law that tells you should jeopardize patient care. Well, no, that's the answer. And by the way, I'm married to an RN who reminds me every now and again, well, you corporate lawyers may make more money than us RNs, but when you make a mistake, someone loses money. When I make a mistake, someone dies. Okay, so you're exactly right. Defining safety sensitive is not an easy thing, but I think employers with positions like RNs giving out meds to people and otherwise treating them, I hope they can stand their ground if they conclude that the best workforce is a marijuana-free workforce. I just don't know that it'll be an easy time standing that ground in New Jersey.
I think it remains to be seen. Oh, there's Kevin.
Hey, great discussion, guys. There are some questions in Q&A that I want to make sure we get to before we turn it off. So let me ask you a couple of these. The one person said they're headquartered in PA. Employees are remote for now. If they're working in New Jersey remotely, does that the law that would apply to them, to the employees?
Oh, another question we dodged because we don't know the answer to. No, but it relates to a larger question. Is that we all went remote a year ago. There's a lot of employers based in PA. They've got employees in Delaware, employees in New Jersey. They've been working from New Jersey for a year now. Does the employer's position that this is a Pennsylvania job, does it still really apply? And the answer is, I don't know. It is a bit scary. New Jersey is frankly notorious for exporting the effect of its laws. I would guess a New Jersey court would say that this medical marijuana law applies to someone working from their home in New Jersey for a Pennsylvania employer, even if they used to show up every day in Pennsylvania.
And it'll be interesting is, we shared that survey earlier that most companies are going to go to a hybrid model. Again, hopefully that allows some certainty in terms of, a single law versus multiple laws applying if you're working 2 days in Pennsylvania, then virtually at home.
Yeah. And this whole thing, issue of where is the situs of someone's employment is a huge issue now, not just medical marijuana, just on
Right.
every law,
All the laws, right?
Payroll tax.
Yeah.
Yeah. Although we'll probably have another session on that because you're right, that's a far-reaching implications. I have a question here. A candidate tested positive for marijuana, so it's a job candidate. He claims he was tested positive because he used CBD oil because he has trouble sleeping. Our client has indicated they will only provide candidates who have successfully passed a background and drug test. Any thoughts about how to proceed? CBD oil shouldn't test positive without THC. But,
Yeah, my understanding is that the levels of THC and CBD oil are pretty low, so it seems unlikely that that's the real excuse. Well, they
Right.
might need an expert to opine on that if the thing went to litigation. I think it's really going to depend on what state you're in and what the state's requirements are. I would, assuming you're in a state where maybe, I mean, honestly, this is not a medical marijuana claim or a recreational marijuana claim. This is somebody who's just saying it's a false positive.
Yeah.
So I think I would look into the science behind whether that's a valid false positive or not. I suspect the answer is no. Dan, I don't know if you have thoughts on that.
No, and to supplement that, if it's set up properly, I mean, they do the drug screens, but I think before the employer is even told it's a positive, there's a medical review officer who looks at the results, has a chance to call the candidate and say, I see a positive test here. What's going on? And the reason I know this is in the 90s when I was trying these cases in labor arbitration, people test positive for cocaine and they'd say, oh, I took Tylenol with codeine. That must have triggered it. But there's been a call with a medical review officer who says, no, I know the science. Tylenol codeine does not cause a positive for cocaine. And here I would guess the medical review officer would say the same thing.
Okay. A question here, which is kind of going the other way. So we have a skilled manual labor groups where a high number of users for recreation, and that's now growing with medical. They don't want a strict policy as that would cause a massive turnover and being unable to operate as normal. So what kind of policy can you make just that kind of identifies non-use at the job during the job hours or facility?
Oh, I'll take that one. You can not test for it, initial screen or otherwise, but an employer, can always supervise people, but also can have a policy calling for sending people in for testing if they're showing signs of impairment on the job. And hopefully you'll have, on detecting impairment as opposed to exercising their general judgment. I think MEA offers some excellent training on those lines. But you can have something short of zero tolerance and focus very much on the job conduct and performance.
Okay. Trying to see if I'm trying to do one more. So I think, so if somebody, one here is a contractor and their employees travel in multiple states, even though they're, for servicing clients, is that the employee as he travels is still probably subject to the home state, but the question would be, what is that? The person they're working for might have their own requirements as to, in each state. So I think it's kind of ties to the vendor issue that you raised earlier, that if you have people going to your customers, you have to consider what their policies as it relates to your employees, and then how do you want to establish a policy?
Yeah.
So, all right. Well, this has been great. This probably is going to merit a further having you guys on in the future as things become clear, maybe especially after the regs from New Jersey. But thank you very much, Dan and Janice. That was great. At this point, we're going to turn it over to Amy.
Great. Thank you so much, Kevin. And thank you to Dan and Janice. That was great. And as Dan mentioned, MEA does reasonable suspicion training. So if you're looking to have your supervisors trained, that's something we can certainly help you with.